Heim Home Group, brokered by EXP. Today in my office, I have Andrew Bernstein, who's an attorney in Northern Jersey and New York. Hey Andrew, how are you?
Hey Alon, I'm doing well. Thank you for having me on the show. I appreciate it.
You're welcome. Always a pleasure to see you. So today, what we wanted to cover is how an attorney fits into a transaction in Northern Jersey, which that's where we are today. That's where I operate my business out of. So in a real estate transaction, if you're buying or selling, it's a complex,
Keep going. You'll cut this out.
it's a complex process.
There's a lot of moving parts.
In
Why
a,
don't you say, hey, try it again. You might be able to use some of that
a
clip.
real estate transaction, either if you're selling or buying, it's very complex and there's a lot of moving parts. So Andrew, tell us how you fit into that puzzle.
Absolutely, Alon. You're exactly right. In each stage of the transaction, there are a lot of different pieces, a lot of things that can go right, a lot of things that can go wrong. The attorney's job is to interface with the other side, to protect the client's interests, and simultaneously to keep things running on track. We are somewhat of a center point where the various moving parts intersect, the various agents being, the various players being the agents, mortgage, title, inspectors, surveyors, appraisers, and a series of other individuals who are involved in the deal. Our role is to interface between ourselves, whether we're the buyers speaking to the seller's attorney, or vice versa, to kind of interact and interplay.
Okay, so you mentioned a lot of pieces here, title company, inspectors, and mortgage companies. So when do you actually come into play? The real estate agent is the one that's working with the buyer or seller usually until the contract is signed here in New Jersey. When do you come into play and how do you start there?
Absolutely. So in New Jersey transactions, the traditional method of getting things together is the buyer's agent fills out a quote-unquote offer, which is in fact a 14-page contract. They send that to the seller's agent. The seller's agent has that signed by the sellers, and once everything is executed, it goes to the attorneys. Typically there's an intro email sent out, here's all the parties, here's everybody that's going on, attorneys, please start attorney review. We talk about attorney review. This is the opportunity for a lawyer to review the contract that the agents have written and give feedback and edits and changes based on the specifics of the deal that may not have been available to the agent or based on the attorney's experience in the field. After doing a couple of thousand closings, people tend to get a sense for what's going right and what's going wrong, and these are the things that get negotiated. The methodology is typically to send a rider by the buyer side, a series of changes they want seen to the contract. The seller side will then either redline that rider or send a rider of their own. The attorneys push it back and forth, then we go to our clients and review these changes with them. Once both clients sign off, we're officially under contract, and at that point, nobody has an exit right without a reserved contingency.
Okay, when you say reserve contingency, you're talking about the contingency of inspections, if it was in the contract that we will do inspections and we have the right to do inspections, and mortgage contingencies. Those are the contingencies that usually I know of, and of course title has to be clear.
Correct. So within the mortgage contingency, we in fact have two contingencies. You have the ability to get the loan, and you have the appraisal piece of it, which goes into the calculation. The appraisal contingency is sometimes written out, where it says if the house doesn't appraise for X dollars, you have a renegotiation and back out, right? Sometimes it's inherent to the mortgage contingency, where the bank's not going to give you the loan unless the house is worth a certain amount, so we would get a denial if they're underappraised. Occasionally you hear people talking about appraisal waivers. We'll jump down that road a little bit later, but those are your base mortgage contingencies. On the inspection side, there's actually a series of inspections that are done. You have your base home inspection, you've got your wood destroying insect inspection, you've got your oil tank sweeps, you've got your environmental studies if you need them. Occasionally people do septic and sewer work, and you'll from time to time see chimney inspections, roof inspections, a lot of various things that come up. If things go wrong, or if the results of those inspections aren't satisfactory to the buyer has the opportunity to present a list of things they want fixed in the house. If the seller refuses to fix those things, the buyers have a backout right or exit contingency. Last piece of it is title. You said it exactly right. We want to make sure that at the end of the transaction, only one individual, or two if there are two buyers, owns the house. You don't want liens, judgments, or claims against the property, and you don't want ownership rights in any other individuals. That is your title contingency. If there are issues that cannot be cleared, then the buyer certainly doesn't have to buy the property. Things get more difficult there.
Once the attorneys receive the contract and they review it and approve it at the end of the day, all parties agree on stuff. Just to make it clear, the buyer has the right to choose the inspector for the home inspection, oil sweep, and chimney. It does not come from the attorney. The attorney could recommend if they ask him. Title companies, a lot of times the attorneys will work with the title companies that they work with and have a relationship, unless the buyer has a relationship and knows of the title company and could request that from the attorney.
Absolutely correct. So every single vendor in the transaction, when you're on buyer's side, is working for the buyer. What that means is the buyer has the right to choose almost everyone. I say almost because mortgage does choose the appraiser. With the exception of the things from bank side, buyer chooses whoever they want. They choose their own attorney, they choose their own title, they choose their own mortgage, they choose their own inspections, and their own homeowner's insurance. With that said, most people don't know a good title insurance company, and they lean on the attorneys to select one for them based on the industry expertise and kind of the attorney's experience in those subjects.
Correct. I just wanted to put it out there so buyers are not confused that they have the right to choose and they're not.
And it's very important. Who you work with at each of those junctures is highly rated. When you work with an inspector, you need to choose somebody who has the industry expertise to handle things that you aren't familiar with. I work with investor clients who are going to be demolishing a house. The only thing they need to know about is whether or not there's an oil tanks and whether or not there are structural issues. I work with a first-time home buyer who's never flipped an electrical breaker. I want someone who's going to review that house top to bottom, explain every single thing about the house to them. It's partially issue spotting, it's partially education. Same thing with attorneys. When you're working with someone who doesn't need their hand held through the whole transaction, you may want to work with a different attorney than someone who wants full details start to finish.
Okay. So I just wanted to understand, in most of the states around the country, there's a standard contract that the agents fill in, and everything, all the closing is done by a title company. In Northern Jersey, I'm saying Northern Jersey because Southern Jersey, it's the same thing as other states. They use a title company for closing. Why in Northern Jersey don't we use the standard contract that we have? Why do we have to rely on an attorney to jump in?
So it's a great question. First of all, you don't. There's no requirement in Northern Jersey to have an attorney. The reason that people generally go ahead and get an attorney is because they're looking for someone to specify their legal rights. The big issue is the unknown. And in Southern Jersey and a lot of other states, what happens is the agents are kind of relied upon to deal with things when things go wrong. And when there is a massive issue that comes up, there is often an ambiguity in the contract and things go to litigation. Litigation is expensive, it's time consuming, and attorneys provide the opportunity to set all of these matters straight ahead of time. The base contracts do a great job of laying out the details of the deal. They do not do a great job of delineating everything that can go wrong. I like to say that 10,000 things can go wrong in any given transaction.
That's 100% true.
If you don't have the rules set at the beginning of the game for what's going to happen when something goes wrong, you're left with an ambiguity. Ambiguity lets parties negotiate or ends in litigation. And when there's tens of thousands, hundreds of thousands of dollars on the line, it makes sense to spend the fee in order to get an attorney who's going to set the rules correctly. And that's what attorney review is. It's setting the rules of the game.
That's very good. I think that we did a good job explaining to the crowd here why it's important to have an attorney in a transaction, how it protects them, and what role the attorney plays. So, just so everybody knows, choose an attorney that you could work with. Interview a few attorneys. Don't just take an attorney that was recommended by somebody because somebody said so. You have to be able to communicate with that attorney, and you have to feel comfortable with that attorney representing you. Just like you choose an agent that you feel comfortable working with, you need to choose the right attorney as well.
My advice to everyone is to always speak to at least 2 or 3 attorneys before deciding the right one for you. There are questions that you should be asking in order to get an understanding of who the right attorney for you is. Things that I recommend to people when they're shopping around or when it's friends or out of state, I always say first thing you need to check is who am I going to speak with through the entire deal? Am I speaking to a legal secretary, a paralegal, or an attorney? Second question, do you have expertise in this area? What areas of law do you as an attorney practice? Because we do have people who are part-time real estate. We have people who do a closing once a month. We have people who do 500 closings a year. You want to work with someone who is familiar with both the region that you're in and the area that you're in. Very important. Finally, very important question to ask, what happens if the deal doesn't close? Does the attorney have a cancellation fee? Does the attorney charge you money? Are they going to chase after you? Are they going to not charge you unless the deal closes? And when you're analyzing those things, you have to sit and think, what is the answer that I want? Everyone likes the idea of things being free, and that's normal and natural, but do you want somebody who's more motivated to close your deal or more motivated to represent you? And that's a question that should be asked by each individual buyer.
100% correct, Andrew. Everybody should ask those questions and know who they're dealing with, because we've seen along the way, I've seen at least, attorneys that have never done a real estate transaction jump in, and it's not helpful to their client or to the transaction.
No, it's not. And the fact of the matter is, when people come in not knowing real estate, or knowing real estate in another state, and coming in believing that they can just apply that knowledge, they're missing what I like to call the range of the pendulum. Everything that we discuss, everything that's negotiated, there's a range of normal. There's buyer favored in a strong buyer's market, there's seller favored in a strong seller's market, and every provision can swing in either direction.
Right.
If you don't know the standard ranges of the pendulum, you don't have any business working in the field, because you're not doing your client any favors by asking for things that are going to jeopardize their transaction. You should have an understanding of what's normal. If you're asking for something abnormal, you should know you're asking for something abnormal. I'm not saying that you can't ever ask for things that are insane. I'm saying you should know that they're insane before you ask.
Of course, 100%. So I think, Andrew, this was very educating to me as well, and to the crowd out there. So if anybody has any real estate questions, you can feel free to call me at 201-638-0903. If you have legal questions, you can talk to Andrew and call him at
908-589-8988. My extension is 1, but anyone at my firm would be happy to speak with you.
And from my experience, you can call almost at any time, and they will pick up and they will answer your questions.
Thank you so much for having me on the show. I really appreciate it.
Thank you for being here. It's always a pleasure seeing you, and looking forward for our next transaction.